Hello, everyone who has joined so far. Welcome, and we're going to wait just a few more minutes to make sure everyone has a chance to log on. So we'll start in like a couple minutes. Hello, all, and welcome to our webinar today on an inside look at the March 2025 policy update packet. We're so glad you were here to join us, and hopefully you'll gain a little insight, and we'll be provide the opportunity for a little insight into our March 2025 update packet. Next slide, please. So before we get started, we'll just take a little bit of a look at what our presentation looks like today and how the agenda will run. So first, we'll just do a little bit about housekeeping and presenter introductions. Then we're going to run a couple of polls, a fun one and a second one about who's attending our webinar. We'll have a little bit of a brief overview about Gamut. Then we'll kind of get into the meat of our discussion about the actual policy updates. Then we'll conduct a couple more polls. And then there'll be time, as always, at the end for additional questions. There'll also be time at varying places within for some questions. Next page, please. Okay, so in terms of housekeeping, in terms of questions and answers, if you could please use the Q&A feature to submit your questions. And I think you can see from the picture below where that's located. Just to know, the chat feature has been turned off, so the Q&A feature is really the way to go. And your questions will be answered either in that feature itself in writing or live by our presenters during our presentation. And just so you know that everyone will receive, who's attending will receive a link to the video of this webinar, as well as the slide deck. So you don't have to worry about taking too many notes or anything like that. Excuse me, next slide, please. So in terms of our presenters today, I'm Barbara Laifman. I'm the Director of Policy Manual Development. We also have Dustin Bindreiff, who's a Senior Policy Manual Writer. We have Aaron O'Ray, who's the Manager of Technology, Sales, and Training. And we have Josh Daniels, who is the Chief of our Department of Policy and Governance Technology Services. Next slide, please. So we're going to get off with kind of what we call our fun poll. It's a little practice poll just to make sure we all are aware of how to participate in the polls. So our question for today is wearing white between Labor Day and Memorial Day. So the actual question is it okay to wear white between these two differing days? So option one would be, of course, wearing white is always cool in California. B is OMG, what a fashion faux pas. And C is no idea. I wear whatever is on the top of my piles of clothes. So let's take a few seconds for everyone to have a chance to put in their submission, and then we'll look at the results. Okay, just 1 or 2 more seconds, and then we'll see what all the responses were. Okay, so why don't we take a look at the responses? So it looks like a lot of people like to wear white, 76%. The faux pas is 11%. And no idea is a 12%. So it looks like the overwhelming choice was that it's always okay to wear white, especially in California. Okay, thanks. And thank you for participating, especially for these polls that are coming up. It's really helpful to us to meet your needs better and for us to do our job better. Okay, next slide, please. So our first real poll is the composition of who is attending this webinar. So the first part's kind of got two parts. The first part is, have you previously attended one or more update webinars? A, no, this is my first one. B, yes, I have previously attended one or two. C, yes, I have previously attended three or more. And then the second part is, what is your role in your district or county office of education? A, board member. B, superintendent or administrator. C, executive assistant, or D, others. So we'll take a few seconds to complete the poll. Okay, and why don't we take a look at the results? There we go. So pretty evenly split in terms of attending the update webinars. A little bit more that it is your first webinar you're attending, but really close with attending one or two or three or more. So I'm glad that we do find a lot of repeat customers because that means that hopefully you're finding this helpful, and always, of course, glad to have new attendees and hope you continue with. And in terms of role in the district, whoops, we didn't get to that one yet. Let's see. So mostly executive assistants with some board members following in second, and then administrators and superintendents third. All right. Thank you. And next slide, please. So I'm going to now introduce Erin to present a little bit about using Gamut to access the update packets.
Good morning, everyone. Thank you for joining us. So using Gamut to access the update packets depends on your subscription level. So we will walk through a couple of the options available. Next slide, please. If you are a Gamut Policy subscriber and you're accessing via the Gamut Policy site as a district user, you'll find that the policy updates are available in the policy updates area under the policies drop-down menu, and they are named according to the quarter that they were released in. So you'll notice here we've got the guide sheet and the policies separated out, and they are both accessible. Next slide, please. And if you are accessing the Gamut Policy site as a County Office of Education subscriber, you'll be able to access the county update packets for the policies and the guide sheets from the same area. Next slide, please. If you are visiting the March 2025 policy update from your Gamut Policy Plus site, and you are a district who subscribes to Gamut Policy Plus and has your manual on a Gamut site, you will use your policies drop-down menu to click on CSBA Communications, where you'll find that the quarterly update releases are listed in sequential order there, with March 2025 being at the top. Next slide, please. Similarly, if you have a Gamut Policy Plus site, but you are a County Office of Education, the same drop-down menu applies where you've got the policies drop-down menu to CSBA Communications, but you'll have the county update listed in sequential order at the top of the County Office of Education Policy Updates menu there. Next slide, please. So I want to announce that we have our Gamut Spring webinar series. It's actually launching tomorrow. So to register for that, you can go to the link at the bottom. It is csba.org/webinars. Additionally, we continue to have our weekly drop-in sessions for virtual support. You can come and ask us any questions about Gamut you may need addressed in the moment. And then you can also always reach out to us via our Gamut phone number and email address. Our Gamut Spring webinar series is in 4 parts, one each month through June. Next slide, please. So if you find that you're in a situation where you've missed several update packets, you have some options available to you for services that CSBA offers. We offer a policy manual review, which is a audit that lets you know which policies you may need to update. It shows you the dates of CSBA's samples and when they were updated, and compares it to the dates in your manual for your most recent last revision of policies. Alternatively, we have the policy development workshop as an option where we're able to help you update your entire manual in one fell swoop with a CSBA policy consultant working with you the whole way through that process. It helps you develop a policy manual tailored to the needs of your district or COE. Next slide, please. If you're interested in combining your Gamut Policy Plus subscription with a meetings module, that is something we can absolutely accommodate. It allows you to have both of those modules in one site. So your Gamut site will have a meetings drop-down menu as well, and it allows you to go fully paperless and have everything all together in one single area, which helps you maintain a single user database to keep track of your LEA's contributors, manage people's permissions and access levels to the content within your Gamut site, and then search across your meetings and your policies all in one place using the super functional advanced search feature that exists in there. And there's always remote access to the site available to you as well. Next slide, please. Thank you so much. That's how you get to everything you need in Gamut.
Thank you, Erin. So from here, we're going to start talking about the policies, and we're going to first cover the basics. So next slide, please. Just some things to know, and you're probably aware, but we'll go over the basics. So governing board basically legislates by way of the board policies. We have our administrative regulations, which are really an implementation tool, and they help the superintendent to implement the board policies so that the superintendent is then following the direction of the district or county office of education through the administrative regulation. And again, and especially by the way, phrased it, this structure may not apply to county superintendents just because of the different dynamics between county boards and county superintendents in most jurisdictions. Exhibits are another really to help implement the policy. It's forms, notices, and other implementation tools that are consistent with the policy or regulation to which it relates. And then, of course, we have our board bylaws, which, as you know, are policies that are really specific to the rules and procedures that cover and govern the governing board itself. And we do use policies to refer to the board policies, the regulations, the exhibits, and the board bylaws. So note throughout this webinar and maybe your interactions with CSBA in general, when you hear policies, it could be referring to any one of these 4 documents. Next slide, please. So our manual is in a numbering system from, as you can see, the 0s to the 9,000s. I'll just briefly talk about a couple. Again, the 2000s are applicable only to districts for the same reason I mentioned before about the differing dynamics between the board and the county soup. 4000s get a little tricky because we have 4100 for class certificated, 4200 for classified, and 4300 for supervisorial and managerial staff. Sometimes they're double or triple coded if for either 2 of those groups or 3 of them. The same language would apply to all. Sometimes we also have single because each one for classified, certificated, and supervisorial, it would all require separate language. And then our 9,000s, of course, are the board bylaws. We do have an 8,000 is specifically and purposefully left blank in case we need to add a section. There's over 800 sample policies. And of course, if you go back to my previous explanation, about 550 actual code numbers because many contain additional more than one document for that code number. Next slide, please. So as we talked about, policies is our collective word for all of the samples. They should serve as a starting point. They are samples. And you know, the expectation is that each of your district and county offices will review them and customize them and make them particular and unique to your district or county office. The policies have gone through legal review and we extensively review them, but they do not constitute legal advice. And things may become quickly out of date, especially with the speed of legislation and other changes that go on in our local, state, and federal governments. And just to know that we do have notes, I don't know if you've all seen them, that are embedded to provide context and guidance. They should not be part of the adopted body language of the policy. They are separated out, so it's clear what is the body language. But it is good to be aware of them because they can provide context and additional description and understanding and guidance for the body language. Next slide, please. So we're going to start by getting into now our actual changes and updates that we did to our policies. Next slide, please. So for those of you who attended before, we're going to structure it a little bit differently this time. We're going to cover pretty deeply two topics. One is mobile communication devices, smartphones in schools, and the other is immigration. And we're going to discuss within those highlighted topics the policies that we updated that are pertinent to that. So you can see them listed out here for each topic. Next slide, please. And then we're also going to cover much more briefly the other policies that were updated, which fall under these three categories of student health, achievement, and instruction, operations and employment, and board governance. Next slide, please. So I'm going to introduce Dustin, who is going to start with our first highlighted topic, mobile communication devices, and which includes smartphones in school. So Dustin, please go ahead.
Thank you, Barbara. I'm sure as the audience is likely aware, in recent years, cell phones and social media have become a frequent topic of conversation in education. The state's policymakers have taken note, and recent legislation targeted the use of cell phone and social media in the classroom. These legislative changes impacted two policies in particular: mobile communication devices and conduct. Before I go into the changes, I wanted to touch for a minute on the next slide on the rationale that was used to to make these changes. The state highlighted some of the research I have here, and in developing this new regulation, policymakers focused on research which found that there's growing evidence that unrestricted use of smartphones by students during the school day interferes with the educational mission of the schools, lowers student performance, particularly among low-achieving students, promotes cyberbullying, and contributes to an increase in teenage anxiety, depression, and suicide. So pretty strong concerns there. In addition to the research here, the legislation was impacted by Dr. Jean Twenge's book, iGeneration, which presents evidence of an increase in depression and suicide among teens that may be caused by increased use of mobile device and screen time. According to the research, students in 8th grade who spend more than 10 hours a week on social media are 56% more likely to describe themselves as unhappy than those who devote less time to social media. Additionally, teenagers who spend 3 hours per day or more on mobile communication devices are 35% more likely to demonstrate risk factors for suicide, such as suicide ideation, and teenagers who spend 5 or more hours per day on their devices are 71% more likely to demonstrate a risk factor for suicide. So those are pretty concerning. Additionally, 2 studies from Europe found a 6% increase in test scores when cell phones were removed from the classroom. The results showing that the use of cell phones during the school day can create significant distraction, which results in negative effects on student academic performance and mental health. Additionally, the presence of cell phones and related technologies in the classroom may not only detract from academic performance, but also contribute to higher rates of academic dishonesty and cyberbullying. With that in mind, let's go to the next slide, and I'll highlight some of the changes we made in response to to Assembly Bill 3216. This bill, Assembly Bill was 3216 was chaptered in 2024. This bill shifted the conversation regarding mobile communication devices, including cell phones, smartphones, and so forth. The major shift in this legislation was away from authorizing districts to develop a policy limiting the use of cell phones to requiring such a policy beginning in July of 2026. In response, we created optional language for districts to select and modify to fit their district. Our sample policy contains the option to prohibit cell phones during instructional time or throughout the school day. So when you review those, your district and board is going to want to have some conversation and make a decision of what limitations they want to put on it and what fits their district. We also added some clarifying language related to the search of students' personal electronic devices, stating that devices shall not be searched without consent, except in emergencies or with a warrant. I also wanted to mention on the topic of cell phones that another piece of legislation that we didn't include was SB 1283, which permits boards to adopt a policy to limit or prohibit student use of social media at school. So there was legislation last year, both requiring districts to come up with a policy limiting cell phones, and then they have an additional optional legislation that gives them the option to limit social media use at school. Next slide, please. Assembly Bill 3216 also impacted Board Policy 5131, which focused on student conduct. Here we updated the list of the prohibited conduct to reflect that cell phones shall not be used in an unauthorized manner. So the primary changes were to the previous policy, but there was also some secondary changes here. We also made a slight change adding to prohibited behaviors, other conduct prohibited by education code. Next slide, please. Were there any questions you wanted me to try to respond to or us to respond to, Barbara?
Yeah, we have one, it looks like one coming in. So the first one is, how can we get a copy of the statistics that Dustin recited in regard to cell phone youth risk?
So that's information was taken directly from AB 3216 in the opening of that. You'll also get a copy of the slides, so you'll have it there. But if you just look up the legislation, you'll be able to find it pretty easily.
Thanks, Dustin. And yeah, if you have any questions, also in addition, could also always be addressed to our policy services. And it could eventually get back to us if it's something that we need to provide more detail on. But thanks, Dustin. It sounds like Dustin provided a very good way to access that. So the second question is, what would it mean to limit or prohibit cell phone use to non-instructional time?
The idea there was not when kids are in the classroom, when they're seated. There's going to be, we wanted to develop an inclusive term because you get questions such as field trips or what have you. So non-instructional time would be that time when it's not teacher-led. Do you want to add any more to that, Barbara? I'm not sure that was the best.
Yeah, no, I think that is good, right? Could be recess, could be break passing times, right? Because I think it's, some schools are comfortable with allowing students to use them during those times, and perhaps depending on the age of the student. And some districts or schools, I think, feel very strongly not even during non-instructional time. So yeah, okay, it looks like we have more questions coming in, so let's keep going. Can we prohibit cell phones entirely, or are there required exceptions?
There are required exceptions, such as in the case of an emergency or when a teacher or administrator grants permission. When a licensed physician, they're listed in the policy. So you could see there are 4 exceptions we list. So even if a district said, we ban cell phones throughout the school day, there would be these possible 4 exceptions that are in the ed code that are highlighted in the policy.
Thank you. Okay, it looks like we've got one more question. Are the two options in the sample policy the only options we can choose from?
No, no, absolutely not. Those are, again, all our policies are samples, and you're going to want to adapt those to fit your district. Those are just the common starting points. The main piece of the main point of the legislation was requiring districts to have some policy. So whatever your district chooses to do, that would be up to your district. The main thing is they're going to have some policy beginning in July of 2026.
Okay, thank you so much, Dustin, and thank you for the questions. It seems like we're ready to move on. So next slide, please. All right, so our next highlighted topic is going to be about immigration, and I'm going to reintroduce Josh, who is going to present on this topic.
All right, thanks, Barbara. So I'm going to focus on the revisions to board policy and AR 5145.13. But it's important to know that there are other impacted policies, 1340, access to district records, 3580, district records, and 5125, student records. We will cover those were part of the packet, but those will be covered later on. Primarily because the changes in those three policies related to immigration is relatively minimal, and there were many other changes that were made because of other changes to law. So we're mainly going to focus on 5145.13, but of course, if you have questions about the others, happy to go over it. So just sort of broadly speaking, this all stems from Education Code 234.7, which was passed back in 2018, which required the Attorney General to publish model policy language in April of that year regarding immigration enforcement in schools. The Ed Code also required that districts, county offices adopt policies that have language in those policies that are equivalent to the model policy language that was adopted by the Attorney General. There has been no change in law in sort of relevant in this sense. However, in December, so just December 24, the AG updated its model policy languages. There was no, statutory requirement for it to do so, but it did so anyway. And then it said that districts, and I put should in quotes, update their policies by May 1st to reflect the AG's updated model policy language. It's not clear to me that the law still says you have to update your policy language by, April of 2018. Doesn't say by May of 2025. That being said, you may want to anyway. And certainly, our policy does reflect the new language, although it's not substantially different. It's sort of a refinement of sorts. And as I mentioned on the slide, most provision or many provisions in the 2024 model policy language are same or very similar to what you found in 2018. All right, so starting off with the BP, which is, I would say, as BPs typically are, the broader stuff. I'm not gonna read word for word every single thing on the slide, but I do think it's important because I think it really captures the essence of what the board policy says. And some of this, frankly, has not changed significantly, sort of in a substantive sense from the prior version. We might have reframed it a little bit or rephrased it a little bit in a more precise way, but fundamentally, most of this is not that different. Okay, so in the BP, it says that no student shall be denied equal rights or opportunities, nor be subjected to unlawful discrimination, harassment, intimidation, or bullying on the basis of immigration status, or basically your refusal to provide immigration status. Additionally, the BP directs the superintendent to give parents and guardians notification of the fact that they are provided with a right to a public education for free, regardless of immigration status. The BP also directs that staff should receive training on these issues and know how to handle the situation. In addition, and then this is actually the first three on this slide are what staff cannot do. So staff cannot solicit or collect information or documents regarding immigration status. They cannot seek or require documentation that may indicate immigration status. If something else is permissible, another kind of documentation that doesn't indicate immigration status. And staff shall not provide assistance to immigration enforcement while on duty or during work hours, and this is critical, except as required by state or federal law, which obviously is a big, big, big carve out, and we'll get to as part of the AR. The superintendent or designee is also required to report to the board if there are any requests for immigration-related information. Basically, anytime that there's an immigration enforcement request or action, board needs to know. But board needs to know in a way that ensures confidentiality and privacy. All right, so the AR, I think, is where most people are interested in. And so we've reorganized it to cover 4 somewhat overlapping, but for the most part, distinct situations. The first being requests for immigration-related information or documents. So that might be an email, a phone call. Hey, I like this information. The second is requests to access a student or school grounds. So that might mean I want to interview a student or I want to come onto school grounds for reasons X, Y, or Z. The third situation is when law enforcement officers are on district property for purposes of immigration enforcement. And the fourth is somewhat different. It's when a student's parent or guardian is detained or deported. What do you do? I think it's important to note because there's been a lot of, I think, discussion about this, about these warrants, right? An ICE warrant, what is it? CSBA takes a pretty strong position that we do not expect frontline staff to distinguish between an administrative warrant and a judicial warrant. To make things even more complicated, many immigration violations are civil. So unauthorized entry into the country currently is a civil violation. Remaining without authorization is a civil violation. But some are criminal, and there's sometimes a very gray area between the two. So failure to depart when directed is a criminal violation. And then illegal re-entry after removal is a criminal violation. So sometimes a warrant related to immigration might be judicial and sometimes might be administrative, and you don't always know. And so we generally take the position that, and you'll see it in the AR, that frontline staff should not be expected to distinguish between the two. All right, so walking through these situations, what does the AR say with respect to requests for immigration-related information or documents? Pretty straightforward, only release with parent or guardian consent, a court order or judicial subpoena or warrant, and then notify the parents or guardians of the request. It's pretty rare that these are going to be sort of urgent things. I used to work at a school district, and we would occasionally get requests from law enforcement, and usually it was not like I needed it by yesterday. Sometimes it was pretty urgent, but not always. So if you get one right via email, right, you're going to forward it on to the superintendent, right, or to your district council or county council, for them to review it and respond properly. Okay, what happens when someone's trying to access, want to interview a student or want to access the school grounds? Similar kind of framework, only in terms of talking to students, right, with parent guardian consent, if there's a court order, judicial subpoena, or warrant. In most cases, you're going to notify the parent guardian of the request to talk to a student. If the general issue, is to access school grounds, that might mean notifying the community. But there are some carve-outs to that. So it may be that immigration issues overlap with sort of child abuse issues. And then in that situation, the court order or judicial subpoena or warrant may actually prohibit certain disclosures, or, just in general, right? Like if you are aware that this issue might endanger a student, you're going to want to talk to your legal counsel and decide, who do you need to notice. One of the other policies you should look up within your district when you last updated it is the visitor outsider policy. We updated it, I think, in the last year. But officers must register as any other visitor. This is what the AR says. So obviously that's up to you. But the policy as currently written states that, or the AR currently written states that officers are treated like any other visitor, and they must register. Again, if there's exigent circumstances or some sort of warrant that they're serving, that may not apply. But if they're just wanting to come to campus to speak to a student, then they must register like anybody else. All right. So situation number 3, you have a law enforcement officer on district property. So if somebody has an administrative warrant and no exigent circumstances, then you must first get direction from the superintendent or designee. You must request, and that would basically be frontline staff calling and saying, hey, I got this officer here. They state that they have an administrative warrant, right? So that question is off the table. Superintendent, designee, council, right? Like, what am I doing? The AR further directs staff to request documentation from the officer. So what are you requesting? Why are you here? What's your name? What's your contact information? I need to write down your badge number, anything that identifies them. Notifying the parent, again, in the same sort of way as we did in the prior situation. Basically, the idea is to document as much as possible what's going on and why. Now, let's say that there's a different situation, right? There's a court order or subpoena, but still no exigent circumstances. In that situation, we're really going to want to redirect them to legal counsel. Officer, I'm not authorized to have this conversation, with you right now. I need you to talk to legal counsel. And in most situations, officers will understand that, particularly with subpoenas, that's the direction they need to go to. Now, that being said, the AR says that staff should never physically impede or get in the way of an officer, period. Like, there's no caveat to that. If an officer states that exigent circumstances exist, even if you don't believe it's true, even if it's not true, no frontline staff should be getting in the way of that. And so the AR sort of follows that logic as well. If an officer does overstep their authority, that is gonna need to be addressed after the fact. Asking your frontline staff to make that call is putting them and the district or the county office in serious jeopardy, and that's not what that is not anything that we would be comfortable putting in a policy. All right. Fourth situation. So what happens when you detain when the student's parent or guardian is detained or deported? So this is, again, coming a lot of the model policy language from the AG. So it says release the student to emergency contacts or individual, basically a caregiver. It's very important that you have updated records for students so that you know who you're permitted to release it to. Better be documented either with a caregiver affidavit or an emergency contact. So it's important that those are updated. There is a more sort of a complex piece around that the student can be allowed to continue in the district and they meet residency requirements, but there are some conditions that need to be met. So if you have the situation, definitely confer with counsel. But the general idea is, the state wants students to stay in their district, even if they're, at least be permitted to, even if their housing situation or family situation changes because of a deportation or detention. And as I said before, make sure you update your contact. Okay. Questions?
We do have a couple of questions. So the first one is, does the superintendent notification for the right to a free public education? So is that notification requirement to parents, can that be put in the parental rights notification document, or is there a need for more targeted notification?
And Barbara, correct me if I'm wrong on this, but I'm pretty sure it can be part of the annual notice, but it couldn't hurt to also, be more targeted if you feel that there's a way to do that. I would be cautious though, because again, you're not allowed to track immigration status. And so it would be, you wouldn't want to have sort of a list on the side, right? That this is, and because that list itself would be against the policy and state law. Barbara, anything you want to add on that piece?
Yeah, no, I think that makes sense. And yeah, we could also then run into the problem of other notices that could be targeted that we don't target. So yeah, I think I think that would probably be the best way to handle it. Okay, and then we do have one other question. Where do we find contact info for list of law firms and attorneys? I'm assuming that means to help with the immigration enforcement and response to immigration
Oh,
enforcement.
so you should I'm not sure what the role of the person who asked, but it would be your district council or county office council. So um you know your superintendent, if you don't know who that is, your superintendent probably would, and certainly who would be the right person to ask in these situations. A number of districts have developed sort of cheat sheets, right? Like many schools are going to have cheat sheets for various threats, or they have a whole sort of protocols for various types of emergency situations. Many districts are developing cheat sheets on this topic as well, and that cheat sheet would then have like what number to call in those situations.
Yeah, yeah, and then we also, CSBA's legal services could also possibly provide help if needed. Okay, so we do have still other questions coming in. Is it recommended to not keep birth certificates from other countries in a student's cumulative file? Our district makes a copy to confirm date of birth.
So there is language in the policy about if there are other ways to document something that don't require immigration status, then you should do that. But this may be the only way for a particular student to document immigration status. I think the next question is, must you retain a copy of the birth certificate beyond enrollment? Are there other reasons why that would be important to do? And I've different districts do differently, but I've heard some that just simply show to demonstrate, but don't actually retain a copy. Others retain copies, but then shred. It just sort of depends on how your district verifies the necessary information for enrollment. But it's definitely something to consider is, to sort of ask your enrollment office, what are our processes? What information do we collect that, in some way will show immigration status? And then do we need to do it like that? And do we need to retain that document?
Okay, at this point, 2 more questions, and then we'll see if more keep coming in. Will CSBA, or are they currently lobbying in DC to protect all students?
Honestly, that's the GR department. I know that we, have a whole process about what we lobby on, but I don't know whether this is something that is on our list. I would recommend emailing the GR department, and they can let you know sort of what CSBA is doing in terms of the lobbying efforts around immigration.
Okay, and it looks like this is our last question. What is the contact information for CSBA Legal Services?
We'll put that in the Q&A.
Yeah, that would be great. That's what I was thinking. Okay, I think that's it for now. Remember, if there's any questions about either of these topics covered so far, we can put them in at the end of our webinar as well. So next slide, please. All right, so now we're going to go into our sections where we're going to cover the policies in a much more brief manner. And I'm going to turn it over to Dustin to talk about student health, achievement, and instruction.
Thank you, Barbara. Let's just jump right in. Next slide, please. As part of the state's efforts to ensure decisions about instructional materials are free from unlawful discrimination, SB 153 contained language to prohibit boards from adopting or approving the use of any textbook or instructional material if the use would subject a student to unlawful discrimination. And so this legislation impacted the board policy regulation and exhibit for complaints about instructional materials. The exhibit was just minor updates for formatting. Next slide, please. Policy 5131.6 was updated to add language which requires districts to annually inform parents at the beginning of the school year about the dangers associated with the use of synthetic drugs that are not prescribed by a physician, in particular such as fentanyl. And AB 2690 requires districts to notify parents about the risks of social media being used as a way to market and sell synthetic drugs. There was a couple more here I wanted to touch on. AB 2711 prohibits the suspension of students who voluntarily disclose their use of tobacco product, controlled substance, alcohol, or any intoxicant in order to seek help. SB 997 prohibits districts that serve secondary students from prohibiting a middle or high school student from carrying fentanyl test strips while on a school site. AB 2998 was very similar, and that provides that districts may not prohibit students 12 years of age or older from carrying or administering emergency treatment for students who are maybe suffering from an opioid overdose. A couple last additions here. This policy was updated to add language authorizing a district to use alternatives to the referral of a student to law enforcement in response to an incident involving the student's misuse of an opioid. Next slide, please. Continued to be a lot of new legislation related to mental health. So I wanted to touch on a few here related to BP and AR 5141.5. In particular, SB 153 requires the district by July 1 of 2029 to certify to the CDE that all certificated employees and 40% of classified employees who have direct contact with secondary students receive youth behavioral health training at least one time, and requires the governing board of the district serving secondary students before January of 2026 to adopt a policy on referral protocols for addressing student behavioral health concerns. A couple more here that are worth noting. The policy was also updated to reflect that the superintendent or designee is required to provide at least 1 hour of training to support lesbian, gay, bisexual, transgender, queer, and questioning cultural competency annually to all certificated employees serving secondary students. Next slide, please. Suicide prevention continues to be a concern. This policy was updated to reflect SB 1318, which requires measures and strategies for suicide prevention, intervention, and postvention to include student instruction on help-seeking strategies and resources. Additionally, the description, we wanted to expand the task crisis intervention team tasks to include posting of suicide prevention policy, protocols, and resources on the district or county office website. A couple others here I wanted to touch on. SB 1318 states that the district does not have a school mental health professional. They are encouraged to consider, when reviewing this policy on suicide prevention, whether funding should be identified. The regulation associated with suicide prevention was updated to include definitions of a mental health prevention professional, student suicide crisis, and school mental health professional. Next slide, please. The board policy related to science instruction, a couple quick updates here. We wanted to expand the philosophical statement to specify the board's belief that science instruction include the place of humans in the ecological system, the cause and effect of climate change, and the methods to mitigate and adapt to climate change, and other experiments and activities that foster critical thinking. Next slide, please. Similar changes related to history and social science instruction. We updated the philosophical statement here to specify the governing board's belief that history and social science instruction include a foundation for the appreciation of different ethnicities, the wise use of natural resources, and the responsible management of personal finance. Additionally, this policy was updated to specify that districts with high schools are required to annually observe during the week that includes April 28th, Workplace Readiness Week, by providing information to students on their rights as workers, and that for students in grades 11 and 12, the Workplace Readiness Week observances are required to be integrated into the regular school program. Next slide, please. 6159 related to individualized education programs. This policy was reviewed with the accompanying regulation and updated for technical revisions. In particular, we changed from the use of the term students with disabilities to students with exceptional needs. The AR was updated to reflect AB 438, which requires students' IEPs to include measurable post-secondary goals and services when the student starts high school. So that might be a change for some of your special education departments, and you may want to make sure they are aware of that need to start having those conversations at an earlier time. Next slide, please. 6159.2 is related to NPAs and NPSs. Here, the board policy was updated to have the superintendent or designee verifying that the NPA will serve as a foster youth school of origin, and that student will be allowed to continue there. Additionally, the requirement to notify the state within 14 days of the change of any status of an NPA. Yes. I think I'll turn it over now to you, Barbara. I hope I didn't go too quickly on those, but we can take any questions.
Okay, thanks, Dustin. We're going to try to handle the questions for these sections at the end of the presentation. So we're going to move on next to operations and employment, and I'm going to be discussing these. And I'm going to try to go kind of briefly and just point out some kind of big ideas and maybe some interesting points. Okay, so next slide, please. So in regard to our policy on access to district records, which also comes with an administrative regulation, not much changes to the policy, just that we moved some material over to the AR, which was really more administrative. And in terms of the AR, some interesting topics were the Safe at Home program was expanded to include additional types of violence and abuse. And it is being discovered and determined that this program is helping to protect thousands of victims. And if we look down at the fourth bullet, so that law was to clarify that publicly posting online home address and phone number of any elected or appointed official, that it covers elected appointed officials. So it would cover, for instance, a board member in a district or a county board of education member. And then if we look to the last bullet, this is an interesting one. It permits extending the deadline to respond to PRA requests due to a staffing shortages during a state of emergency. And this difficulty was discovered during COVID. The one exception to it, though, is that it can't be for a PRA which would pertain to the emergency itself. All right, next slide, please. So the next policy that I'm going to talk about is bids. Also has an AR. The big thing here is that we moved a lot of the material from the AR into the board policy. And the reason for that is because it covered board actions, and we really thought more appropriate to have it in the policy rather than the regulation. We like to keep board actions and governance responsibilities in the board policy itself. Okay, let's move to the next slide, please, where we're going to talk about the Uniform Public Construction Cost Accounting Procedures. And in addition to what you can read through in the slide, we do revise this one regularly to keep up with the changes in threshold for the public construction cost accounting procedures. There's certain threshold limits, and depending on the threshold, what responsibilities and requirements exist. So we want to look at this one regularly. All right, next slide, please. And now we are on to our policy on contracts. And one of the interesting points about this is, again, the fourth bullet down, which talks about private labor compliance entities. And what they were finding is that since these entities have the ability to enforce activities on public work projects, that sometimes it was creating a problem with the public work project getting accomplished. It was having a negative impact. So this bill puts some requirements into that, and we've added a little bit into our policy. Just an interesting point, because hopefully it will help the public work projects, which includes projects, you know, that our schools do, to run more smoothly. All right, and now to our next slide, please, which is our policy on emergency schedules. And if we look at the second bullet, this is where we added snowstorms to emergencies for which the district may apply to the CDE for apportionment credit. Interestingly, what was found is that rural districts were being hit much harder by the lack of snowstorms being on the list. So hopefully that will help our rural districts. And very important is the third bullet and sub bullets, which talk about what needs to be in the affidavit for school closures. And this was meant to enhance communication and a set plan for instruction. You can see it depends on when the emergency occurred. If it's in the earlier time, up to July 1, 2026, then the plan is really for offering independent study within a certain amount of time. For emergencies after this time, districts and counties have to have an instructional continuity plan included in their comprehensive safety plan. And then the district or county has to show that they offered engagement and instruction consistent with the plan, or certified that it did not so due to extenuating circumstances. Okay, next slide, please. Okay, so in terms of district records, we included, most interesting to this is information that we included about cybersecurity, since so much of our records now are online. This has become a much bigger issue. So as you can see from the slide, we covered information about that. Next slide, please. Okay, and then we made some clarifications in our AR. And the last bullet I found very interesting because it talks about organizing and filing our records, and we just kind of generalized it because of the reality of how things are. We have hard copies now and electronic. So the idea is to look at it as a whole and to figure out a good way for organizing, really based on the information, the content of the record. Okay, next slide, please. Just a little bit about employee compensation. We can take a look at the first bullet, which talks about the requirement to annually complete and report salary and benefit schedule information for bargaining units. This was already required of certificated staff, now required of classified staff. And the idea is to help for the to create transparency with what people who work in school districts are getting paid. And it's, I know behind the bill, which required this, there was an effort to help with the school workforce crisis and to hopefully encourage more people to, you know, if we can close that gap in wage, to encourage more people to want to work in our schools. Okay, next slide. And this is about employee security. So as you see in the first bullet, this authorizes collective bargaining representative to seek TROs on behalf of employees subject to harassment, violence, or credible threat of violence. And this was part of a bigger bill, which helped to work towards violence, workplace violence protection. Another part, which is really helping to protect our employees, is the where is it? The second bullet down in the AR, what our AR was updated to include. And the idea behind this new law was to create a balance between, or just to really not have an employee who has to make a decision between going to work or feeling safe. And so by providing these accommodations, hopefully the employee can feel safe in the workplace. Okay, next slide, please. And this is the last policy I will be talking about, which was also mentioned briefly by Josh in his discussion on immigration enforcement, or response to the immigration enforcement. And it's our policy and regulation on student records. And again, we highlight safety. If you look at the fourth bullet, or really the last bullet on this slide, and this is a requirement, it's important to know about. It's a requirement of superintendent or designee to develop protocols to comply with restraining orders that prohibits a party from accessing specified student records and information. So very important because it does put a responsibility to develop protocols for this. So that's a requirement that needs to be met by your districts and county offices. And next slide, please. So I wanted to, okay, well, in this slide, again, we talk a lot about the digital impact on student records. And you can read more fully. We're getting a little short on time, but that's basically what that slide stands for. And then if we go to the last slide, what I want to touch on here is the third bullet down about the California College Guidance Initiative. And this is a legislatively authorized service provider with the goal of helping students to plan for and apply to public colleges in California and universities. And it is free to the districts and to students and their families. But it does require a lot of information gathering. So because of that, there's requirements on districts and county offices, including, as you can see, a data sharing agreement, as well as certain notifications that need to go out to the families because of this conglomeration of records that will be in that portal. Okay, next slide, please. Sorry that I ran kind of quickly through those, but we do want to kind of try to get to cover everything that we'd set out to. So I'm now going to reintroduce Josh to talk a little bit about board governance.
Thanks, Barbara. This should go pretty quick. So 3 board bylaws for board governance. First is 9150 about student board members. We sort of cleaned up the bylaw a little bit. There are 2 legal bases for providing for student board members. One is a generic authority that boards can do anything that they're not prohibited from doing, and the other is very specific to create student board members through a petition process. That petition process legislation includes a lot of details about sort of the rights and obligations of student board members. So this bylaw reflects that. It's good practice anyway. So if your student board member position is created simply on your sort of broad grant of authority, most of the things that are included in the policy still would be good to adopt, but you're not required to adopt them because the legal basis for a student board member is much more broad. We also added authorization to provide monthly financial compensation for school board members and to reflect a particular law that just applies to districts, SB 1445, about allowing student board members to make RJ recommendations in the case of expulsions under certain conditions. Then the other 2 bylaws were just quite old, 9224, oath or affirmation, and 9260, legal protection. It's not so much in this situation that there is a change in law, but rather that, I think we last updated them, 20 years ago or something like that. So we wanted to update them, make sure that they were still current, reflected not just current law, but also sort of current language and approach. And so we've done that in those 2 areas.
Okay, as you can see, we're almost ready for our last questions, and we do have some that have come in. But before that, let's go to our next slide, please. Okay, so this is our second poll that we are going to conduct, and it's basically on the topic of the optimal time of our policy update packet release. So as you probably know, we currently release in March, June, September, and December. We're considering shifting this a little bit. And the reason being vacation schedules, holiday times that boards can be in recess, as well as when boards will actually be meeting, to adopt. So, really the 2 questions in the poll is, from your perspective, what is the optimal schedule to release policy updates? So A is our current schedule, which, as I said, was March, June, September, and December. There are thoughts about moving on our part to February, May, August, and November, but we want to do what serves you guys the best. So that's why we're hoping for input on which schedule, if it in your perspective or for your choice, what would you prefer? So I'll wait a few seconds while we complete this. And of course, there's a third choice, either one that, you can go either way. that whatever organization your district does is unaffected by our release schedule. All right, just a second or two more. Okay, well, why don't we go ahead and take a look at the results? Okay, it looks like pretty close between either one and possibly shifting to the other schedule. And it seems like the first choice, it's not really the least choice because either one also works. But so it kind of is borderline, but it does seem like a shift could be a positive thing. There were 41% that definitely said they would appreciate the shift. So that's good to know. And thank you for participating in that poll. All right, next page, please, or slide. Okay, and now to help us do our job better, well, all of this really does help, but really rating how we did would be great. So 5 is incredible, 4 really helpful, 3 good enough, 2 barely okay, or 1 not worth my time. So we'll take a few seconds for this poll. Okay, another second or two. All right, so let's look at the results. Okay, so it looks like most say really helpful. So that's very good. I mean, we always happy to see that our lowest was good enough. So that's good. And of course, we'll always strive to get more incredibles, but we're glad at least the majority felt that was worth their time and worth. So that's really good to know. And thank you. Thank you for participating in that poll. All right, next slide, please. And as we promised, time for some additional questions and answers. So we do have more questions. So, and I'm hoping that my my fellow panelists and peers can help out with the answers. So first question, who decides what is harmful material in instructional materials?
I can take that one, Barbara.
Sure.
1312.2 offers a process that can be used by districts to review complaints on instructional materials. I wouldn't say there, especially for a district that you want to have some person as the sole authority on what is or is not harmful. The main thing you want to have is a process in place if you get those complaints. So what is your district process for reviewing those? Similarly, if you're considering adopting textbook, what is our process to review those? It's not one person deciding that or what have you. Yeah. So hopefully that makes sense. Do you want to add any more, Barbara?
Just that we do, I think that was very clear. Just that we do have a policy on adopting and selecting instructional materials. I think it's 6161.1, but if you need the number, please, I'll double check that. But you could go by the title, which has to do with adopting and selecting instructional materials. But we do have a policy on that too, so that could be helpful. All right, next question. What CSBA resources are available to us regarding alcohol and drug safety currently? So I guess what resources are available? Yeah, from CSBA.
Yeah, I don't know an exhaustive current list. I know research evaluation and policy development, they put out support materials summarizing research and best practices on these topics. The other place, great starting place to look is in the policies, in the notes. We will often reference recent publications from the federal government, the state government, or CSBA if they're particularly related to that topic. So I would suggest start with what is the CSBA. You could probably do a search on the website and get a list of some of their resources. And then you may also want to look in the notes if you're looking for some of the most current stuff that we use to help us draft the policy revisions.
Yeah, and I know that CSBA recently, or within the past year, has updated their webpage on school safety. And I think it does have some information on alcohol and drug safety. I can't promise, but I think it may. That might be another place to look. Okay, let's look at our next question. What was the bill number referencing Workforce Readiness Week in late April? Dustin, do you happen to have that bill number handy?
Oh, I didn't even see that one. Sorry. Let me do a little research. What was the question?
Yeah, we can come back to that. The bill number referencing Workforce Readiness Week.
Okay. Yeah, why don't we come back to it? I'll
Yeah,
do a little
yeah,
quick
that
search.
would be great. Okay. Then the question for student records regarding restraining orders, when does that go into effect? I would have to research that. I believe it is in effect. Yeah, no, I know it's in effect because it was SB 24. I'm almost certain that's currently in effect and that districts do need to have procedures and protocols to cover that. If you want me to double check, just please email me. But if not, you could also look at, I'm almost certain it was SB 2024, and I believe it was an older bill. I think it might have been from 2021, if I'm correct. So that should be helpful for that. Okay, next question. What about power outages for school closures or reimbursements? During recent outages, I think from the fires actually, we had schools without power for up to 10 days. We were able to acquire generators after a few days, but suffered a drop in attendance. Is there any discussion for including power outages and emergency school closures? You know, I don't know. Honestly, I don't know that answer. I do know though, when we had fires down in our area here in Oak Park, we were able to, I believe, be able to get reimbursement for those days or days in attendance or attendance that had dropped. So Josh, you might know more though, if it's not specifically listed on that list, I believe there's still ways of getting the reimbursement, but you might know more detail about that.
No, just what you said. Certainly, you want to be in touch with CDE about, the attendance waivers and things like that. And if this was a situation related to the recent fires, then I'm pretty sure that they've loosened up quite a bit of the restrictions to get reimbursed for that. Or sorry, to get waivers for that, excuse me.
Okay, next question. Can you explain in more detail how AR 1340 access to district records helps victims? So you might have, maybe I was going a little too fast. So I mean, hopefully the AR itself will by including this information, but it definitely, it includes the Safe at Home program in our language. So hopefully that will help by having that language in there, and the addresses and everything not going out through the Safe at Home program will help people not be victimized due to any records at schools. Is that clear enough? Okay. Next question. Are there additional resources for districts to go through a process in terms of selecting a student board member? Is there a place to see data on how many districts have student board members? So I guess the first part of the question is a process for selecting student board members, and then the second is data. Yeah.
So if your board member exists because of the petition process, then the law requires that there be basically a vote sort of by the students. And it's phrased slightly differently in the policy. If your student board member exists because of just the generic grant of authority to school boards, then you can basically come up with whatever you want as long as it doesn't violate some other law. In terms of a list, there is a student board member association. I don't know how active they are, and I don't know to what extent they track how many different boards have student board members. I'm not aware that CSBA does that. I know we track, traditional board members, but not student board members, to my knowledge. I bet if you Googled California Student Board Member, association, you might get lucky. So yeah.
Okay. Next question. Do boards have to adopt a local resolution if the board is now going to have a student board member?
No. So it really, I mean, we would recommend policy. So, resolutions typically are for things that are sort of one-off kind of statements, but if you have a student board member on an ongoing basis, you're going to want that to be reflected on policy. And so you'd want to adopt some version of the bylaw that we have. If you don't have a student board member, you still would probably need to have the bylaw, because it would provide for how via petition the students could, basically could advocate for the creation of a student board member position.
Okay, thanks, Josh. Okay, next question. Will there be updates to Title IX policies soon? Yes, we're currently working on them. So it's on our radar. It's one of our priorities right now. And yes, we will be sending out updates soon. Next question, for textbook adoptions, is this for supplemental materials or for core materials? And what is the policy number for core materials?
Barbara, I answered that. The policy on textbook adoptions, selection and evaluation of instructional materials is 6161.1.
Thank you.
So you were right about that.
Okay, great. And then, Dustin, were you able to get also a bill
Yeah.
number referencing the workforce ready weekend?
AB 800 of 2023. Assembly Bill 800 from 2023, and it impacted Education Code 49110.5.
Thank you. Okay, so and I can just briefly go back to the Title IX a little bit. And we're going to probably write an article about this too for CSN, just about our process. We can't just go back to our policies as they existed prior to the 2024 adopted regulations, because we had added some new information unrelated to the Title IX regs. So we want to make sure we maintain that, as well as making some other, honestly, just stylistic improvements, things like that. Plus, we have new information to add. So it's not as easy as it sounds to just go back. We can't do it that way, but we're working very diligently to get them out to you. So with that, next slide, please.
There was one final question, Barbara.
Oh, there is a final question. Sorry, I must have missed that when I thought we were done. Okay. Is there ever policies, regulations that are considered mandatory to update it? So are there any on this March update? So yes, there are mandated policies. We keep a mandated policy list, which we update with each of our update packets. And that should go to districts. I mean, I know it gets sent to districts, so hopefully it gets to you with each of our packet releases. And yes, there were some on this March update. Even a couple new ones, like the mobile communication device, that became a new mandated policy. Others were updates to, I think there might have been one more too, updates to policies that we already had on the mandate list. But if you need help finding or accessing that mandate list, please let us know, because that is a very good and useful document.
And I'll just add that the mandate list includes a list of policies where the state or federal government says you must have a policy on this. That being said, the other policies there are other policies that you need to have. The example I often give are the bylaws. We just were talking about the student board member, right? So if you have a student board member, you're going to need a bylaw about what that student board member can access, what they can do, what their authority is. And if you don't have that, there's zero guidance for that student board member's interaction with the board. So it's true the state doesn't mandate that you have it, but you need it. Otherwise, the basic functioning of the district is going to be impaired. So I wouldn't want anyone to think that the mandate list is the only thing you need. It's just that is the list that the state and the feds require you to have a policy on from their perspective.
Thank you. Okay, I don't see any more questions, so I think we're good to go to our next slide and kind of close up. So just a big thank you to all of you for attending, for participating in the polls and with your questions. And thank you to my co-presenters for their thoughtful presentations. And that's it, and hope to see you again next time.